Happening now, a hearing is underway in Middlesex County Superior Court as Market Basket officials seek a restraining order against two former executives. Let's listen in.
All right.
Good morning, Your Honor. Peter Gelhar, which is spelled G-E-L-H-A-A-R, or the respondents, defendants. And with me today is Erica Spencer.
All right, welcome.
Thank you.
How do I spell your last name again?
S-P-E-N-C-E-R.
Spencer, I'm sorry. Okay. All right. I've read everything. The defendants, Mr. Schmidt, Mr. Gordon, by way of their attorneys, submitted an opposition this morning. Did you see that opposition?
We were handed the opposition just outside right now, but I've had a chance to look at it, yes.
Okay. All right. Do you need more time? Are you all right with that?
I'm all right with it, though I might have to refer to it if something came up.
Yeah, okay. Well, I've had plenty of time to go over it, so I think I understand the issues with respect to the defense. All right, so this is Demoulas's motion, and I'll hear the moving party.
Your Honor, the defendants are two Market Basket employees who were put on leave 10 weeks ago and terminated from their employment 3 weeks ago for disrupting Market Basket operations and defying company directives. One of those directives was, quote, to refrain from entering upon the premises of any Market Basket store, property, or office without the Board of Directors' approval. That was in letters that were handed to them and FedExed to them on the date of their separation on May 28th. Since that time, the company has reminded them of their obligation to follow that directive on several occasions. And notwithstanding those repeated warnings, the defendants keep flagrantly defying that directive by intentionally trespassing on Market Basket properties.
So the first warning was in the suspension letters on May 28th?
Correct, Your Honor.
And the next one, by my count, I believe was, well, they were terminated on July 22nd, correct?
They were, but before that, they received another letter that essentially, before that, they had trespassed on a couple of properties, and they received a letter identifying those as flagrant trespasses on Market Basket property.
Let me get the complaint up, and it's a verified complaint, right?
That's correct, Your Honor.
All right, so let me get the complaint up. Where's the letters on there? I have a May 28th letter.
Those are exhibits A and B.
Right.
And then the ones that I'm referring to are C and D.
Hang on, let me find those. Well, that's a June 26th letter, right?
Correct, Your Honor.
Okay. So we have, okay.
So you can see there in the second paragraph, it has come to our attention.
Yep.
Yeah. Then, after they were terminated, shortly after that, they began this campaign of trespass, where they trespassed in 25 different stores over the course of 6 days. As soon as the company became aware of it, it immediately reached out to both of them on multiple occasions in multiple ways to again reinforce that no trespassing order that had been issued to them back in May 22nd was still, or May 28th rather, was still in effect unless they had any doubt about it, although there was no reason to have doubt about it because they had never been told that they were authorized by the Board of Directors to enter any Market Basket property.
So was that notice, one of them was an August 6th letter?
Correct.
And then the next, it was same date, was an August 6th voicemail message to them?
Yes, Your Honor.
Okay, so we have May 28th, June 26th, August 6th, twice. Is that right?
That's right, Your Honor.
And that was to both Mr. Schmidt and Mr. Gordon, correct?
Correct.
Good.
And then, of course, I just mentioned that right after we filed, just last week, right before we filed the complaint, the defendants trespassed at these 25 different stores over a 6-day period. But within that week, just last Thursday from today, Defendant Schmidt illegally entered Market Basket's locked headquarters after hours, equipped with a master key that he had refused to return until just 2 minutes ago in this courtroom that opens every office in the building.
And so that visit to that's the visit to the company headquarters in Tewksbury on August 7th, right?
That is correct, Your Honor.
Okay. And the 25 different stores, that's between the 28th and August 7th?
No, that's between the August 4th and August 9th. So that was a 6-day period.
Okay.
And I believe August 9th was either a Thursday or a Friday.
All right.
August 9th was a Saturday. We filed our complaint the following Monday. Your Honor, the Supreme Judicial Court ruled nearly 100 years ago in Pease v. Parsons that a victim of repeated trespasses is entitled to an injunction to prevent continued injury in the future. And the SJC has repeatedly reaffirmed that holding over the years. And a session of this court actually applied it just a few years ago in the Turo case, which we cite in our briefs. These cases all hold...
Mass Port Authority versus Turo 487, Mass 235, right?
So the Turo case...
That's the case I have
Yes.
standing for it. I don't know if you cited it, but that's the case I have standing for that proposition.
Yes, and the lower court opinion as well.
Okay.
That's right. These cases all hold that the plaintiff does not have to prove irreparable harm. The SJC specifically wrote in the Pease case that irreparable damage is not essential where repeated trespasses are alleged. Instead, once the plaintiff proves that the defendants have committed repeated trespasses, the plaintiff is entitled to an injunction prohibiting future trespasses.
Now, I imagine that the defendants are going to say something about continuing trespass. This isn't a continuing trespass. So why don't you tell me what the irreparable harm would be, assuming that there is not a continuing trespass? I'm not saying that's true, but now's your time. I want to see, how would you say that there is, despite the case that's been cited, the Turo case, how is there irreparable harm to Demoulas in this case?
Yeah, so I will answer that question. I would point out first that the courts tend to use the phrase continued trespass and repeated trespass interchangeably. Some of the cases that we've just discussed involved repeated trespasses, golf balls being hit into a property, a bus being driven across. And the court has identified, the Supreme Judicial Court has identified the mere violation of the right to exclude others as being irreparable harm. It's sort of essential. It's in the nature of a property right. It can't be repaired with damages. An injunction is the only remedy, and therefore that's the remedy to which the plaintiffs are entitled. In this case, in addition, however, these individuals were former high-level executives of Market Basket. Many of the people in these stores who they are going into reported to them, were in a position to be disciplined by them, be fired by them. And so when they come into the stores, those individuals who are working there don't feel free to just ignore them. The defendants, from the day they have been terminated, really from the day they've been suspended, have been waging a campaign in the press where they have suggested that the right course of action and the course of action they anticipate is that Mr. Demoulas, who is the CEO, who was suspended at the same time, and they themselves will one day be back. And the individuals who they are talking to in these stores, in some cases, these are individuals who will tell you that they had been there, working there for 15 years. Mr. Schmidt, who they reported to, never spoken to them once before in their lives. Now all of a sudden he's in there saying, oh, how's your family? How are your kids doing? How's the business?
But now we're getting sort of down into the weeds of a different complaint, different issue. This is a trespass complaint, right?
Yes.
And so how is the trespass itself causing irreparable harm? Now, I know, you sort of have to think about the basis of, what's happening behind the scenes, so to speak. But, talking to employees, is that causing irreparable harm? What's the evidence of that?
Well, we have a verified complaint in which an individual who has heard from many of these employees have indicated that this conduct is frightening to them. It's distracting to them. It's discomforting to them. The message that they're receiving is that they have to worry about what's going to happen if they continue to do their jobs, if they don't agree to go along with whatever Mr. Schmidt and Mr. Gordon and Mr. DeMoulis have planned to try to restore themselves to their former positions. And so it not only is distracting the employees from doing their job at the time, but it is making them very uncomfortable, and it's causing a lot of apprehension, and that is disruptive to business. And that is not, that is the type of harm that one associates with trespass. It's something happening on your property that is injurious to you, and the courts have held that that uniquely is a harm that is reparable by equitable relief as opposed to damages.
Right. What about the harm which sort of stood out to the court when I'm reading the papers, and that is this August 7th visit to the Tewksbury location where I think it was Mr. Schmidt, I might be getting that confused, but I think it was Mr. Schmidt went into the offices with a key that he had. Is there allegations or some kind of evidence that that there may have been materials that were taken or looked at or what have you? I mean, the very nature of that, I know itself, that act, I get your point that might be, that's harmful or could be very harmful. But do you have any evidence, specific evidence, that says that intrusion was for the purpose of finding documents or something of that nature, or taking documents?
Well, so that's one form of harm. And we don't know what Mr. Schmidt looked at in people's private offices, what he may have taken with him, because cameras aren't trained on people when they're working at Market Basket. But we do know that he entered, he stayed for a little while, he had a key that would let him into any room in the building. And in addition to that, there is a harm from people who work in that building and people who work throughout the Market Basket family in knowing that this individual who had a lot of power over them can seemingly go and do whatever he wants, go wherever he pleases. He can go into their stores, he can go into their offices, he can, it seems that his view is that he can enter at will, and that Market Basket's directives to the contrary don't bind him. And in particular, he's doing harm to the company's reputation. He is doing harm to the respect that the public has for the company and its management and the board of directors by openly defying these directives and acting as if the current management and the current board of directors of Market Basket are not in control of the organization. He's the one who's in control.
Okay.
I'd just like to address a couple of things that I saw in Defendant's papers. Before I do, just bring the court back to the point that this is, according to the law, irreparable harm is a matter of law.
Yeah.
So, I think
I understand that. I'm just,
Yeah. All right. So, defendants claim in their papers that they believe that they were welcomed into Market Basket.
I saw that quote.
Yeah. So, under Massachusetts law and under the restatement, the defendant's belief is irrelevant. even if it's a good faith belief, even if it's an actual mistake of fact, although we question the credibility of that. But putting all of that aside, the only question is whether they were actually barred, not whether they thought they were barred.
I was curious about that, Attorney Spencer, or Attorney Spencer or Gallagher. I don't know who's arguing it, but
I am, Your Honor.
You are. I'm curious about that. What does it matter whether they felt like they were welcome? I mean, really, I sit here and hear criminal case after criminal case, and the excuse that, well, I didn't know it was wrong. I mean, or I thought it was okay to do. I mean, that's never an excuse, is it?
Well, but I appreciate the question, Your Honor, but that isn't really why we submitted that not hearsay evidence to you. It wasn't to show what they felt. It was to show what they saw, and that proves the consent. So in other words, it wasn't that they felt they had consent. They looked, they heard, they listened to the captains of the ship of those stores.
Understood.
And they said, we're glad you're here, okay? Those are clear and unequivocal words of consent
So do
from
you
the
have
captain of the ship.
Do you have case law that says that an employee's consent of a person to enter onto a property, even after that person has been specifically informed that they're not to be on that property, in fact, they've been warned not to on numerous occasions. Do you have a case that says an employee can override the employer's specific directions and therefore consent to a person entering on that property?
We can supplement our briefing, Your Honor.
Well, no, you've had a long time.
We had 2 days, Your Honor.
Okay, but that can't be a hard case to find. Is there a case that you know that says that? An employee can consent on behalf of an employer to allow someone who's not supposed to be on the property to be there?
We believe, Your Honor, that that's a factual issue. And trespass, the affirmative defense of consent is a fact-bound issue. And so it depends on what the facts are surrounding that consent. And so if an employee with apparent authority who runs the store says, you may be here, then that is enough for the person to be there.
Okay.
And it forms that common understanding between the person going in this case, Mr. Schmidt and Mr. Gordon, who both believed that after their terminations, leaving the suspensions aside and whatever restrictions they had before then, when they were terminated, they're free citizens at that point.
Right.
Now, and I think the court asked a really good question, that is, where was the termination letter in the complaint? The plaintiffs did not add or append the termination
July
letter.
22nd, right?
Correct,
Right.
because there's no restrictions that are mentioned in that.
Was it needed? It was in the 28th and in the 26th notices to them. They'd received, and the notices, I look at the language pretty clear, saying stay off the property.
Your Honor, I think the world changed between the time when they were suspended and when they became private citizens. When they were suspended, they were employees of the company, and they were given directions as employees.
Okay.
And they were reminded in those letters that the court saw, you're still employees, and we can still tell you what to do. Then the termination letter entered, and there's nothing in that termination letter that says, what are the rules of the road going forward? So at a bare minimum, there is some very hazy rules of the road as to what is okay to do going forward.
Okay. Understood. I'm sorry, I interrupted you. Do you have more?
I just wanted to respond to that, Your Honor, if I might, which is to point out that although we disagree that an employee under any circumstances has apparent authority to give consent when the board of directors has instructed the person specifically that they're barred. In this particular case, the May 28th letter said that they were barred unless authorized by the board of directors. So the board of directors explicitly made clear that they were not giving consent to anybody other than themselves to authorize the defendants onto the property. There's no allegation that the defendants ever got that authorization, nor could they have. The fact that, of the many, many letters that were sent to the defendants over time telling them that they were violating company policy and company rules, that one of them just didn't happen to repeat this morning is irrelevant as well. There's no requirement that you be barred in every letter you receive. Once you're barred, you're barred.
Understood. All right. I'll hear you.
Your Honor, I want to be helpful to the court and not go through my argument that I had planned. If there's something that seems like it's of great interest to the court, I'm gathering that irreparable harm is of some interest to the court. I'm happy to go with that first, if that pleases the court.
Yeah, I mean, I'm not saying that I'm rejecting the Toro case and the proposition given by Attorney Weinrod, but I still want to, in the alternative, I'd like to be able to hear what the irreparable harm is, and so that's a nice lead. So what's the irreparable harm to your client who no longer works for Demoulas, no longer has any business dealings involving that business? What's the irreparable harm to your client if they're not allowed to go on Demoulas' property?
Well,
is it the cheap prices that they're not going to be able to get, or what?
Fair enough, Your Honor. No, the irreparable harm, Your Honor, is the entry of the injunction against Mr. Schmidt and Mr. Gordon, because that will cause enormous, incalculable, really irreparable reputational damage, and I'll tell you why. Because the cause of action of civil trespass is not well known in the community. Everybody thinks trespass is a criminal problem. And so to their friends, their market basket colleagues, to the public at large in the newspapers, it's going to sound like an injunction entered against these guys because they committed a crime. And that sort of reputational damage is truly irreparable.
Doesn't that happen, though, every time, an injunction occurs? I mean, that's part of the burden. I mean, I have to show a likelihood. I have to confirm that the moving party has shown a likelihood of success. If I were to say, oh, it's not appropriate to give an injunction because my finding of likelihood of success will damage the reputation of the company or the individual or what have you, if that were the argument every time, you'd never have an injunction given.
But in all due respect, Your Honor, that isn't the argument every time. In most injunctions that this court enters is about business people saying, you can't do this, okay? You have to stop selling this, or you have to stop buying this.
I agree.
What I'm talking about is a reputation problem that people think these two guys committed crimes of trespass. And that's not what's being alleged.
All right, well, we can educate the public and say for sure this is not a criminal trespass case. It's a civil trespass case.
I'm not sure that that's possible, Your Honor.
Well, I'm saying it. We can, everybody take it down. Make sure you know it. It's a civil trespass case.
Well, it's still a reputational issue, but I think, Your Honor, what the court has to do is balance that reputational harm with zero harm to the company. There is zero harm to the company, and now we're right in the middle of the irreparable harm argument. The only allegation concerning irreparable harm in the entirety of the hearsay complaint, verified but all hearsay complaint, is paragraph 20, one sentence in paragraph 29.
In the complaint?
Correct.
Hang on, let me get it. All right, I'm there.
It's the second sentence, Your Honor. Defendants have prevented Market Basket associates from doing their jobs during business hours by engaging them in personal, often discomforting conversations, and they have forced Market Basket to spend attention and resources that could have been devoted to customers on responding to defendants' illegal activities. Now, first, Your Honor, let me tell you why that didn't happen. And that is because These two gentlemen know these people, know these store people. They've worked with them in some cases with respect to Mr. Gordon for decades and decades. Nobody said to them, and they're friends, nobody said to them, hey guys, I am really busy right now. The store is packed. You got to leave. I'll catch up with you some other time. In each case, as demonstrated with admissible evidence, not hearsay, to the court, the people were welcoming them. Nobody told them to leave. And so it just doesn't make any sense for them to say that there was all this distraction when not a single store person said, guys, I can't talk to you right now.
Well, that assumes, though, that they're talking about the people, that assumes that they're talking about the people that they specifically talk to. What if they're talking about other people in the stores that see them? You know, when you go into a company headquarters and you're talking to maybe your friends, which is I understand what you're saying, but there's also 5 other people sitting around, and those might be the people that they're talking about, that might feel intimidated, that might feel, what was their word, pressured or frightened or distracted. I mean, that might be them.
But those damages, Your Honor, are compensable by money damages. And
I don't understand that at all.
Market Bass could bring an expert in and say, for example, and this is a very, very elementary example, I admit, but you have a store supervisor that wasted 9, 8, 10 minutes with Mr. Gordon.
Right.
Wasted that time. If they get paid $100 an hour and you wasted 10 minutes of that person's time, then that's $16 damages, okay? Alternatively, they could bring in an expert and that does damage assessments at grocery stores and try to determine whether there were any lost sales. Again, this is all money damages. So it's not irreparable harm. And I think the court has already seized upon the issue, and we think the problem of the issue with respect to this so-called continuing trespass. And if you look carefully at those cases, as I know the court will, those cases are with respect to literally continuing trespasses where there's a building over a property line. There's golf balls that just continually go onto somebody's property and stays there. These are staccato events. 6, 8 minutes in, 6, 8 minutes out. And the case law doesn't suggest that you just add those up and say it's continuing. So they're not, those cases are not apt to this situation. And I can also address, Your Honor, I think a fundamental factual issue with respect to Mr. Schmidt's entry into the warehouse. As he testified in his affidavit, sworn, he went to deliver his car back because he learned that they wanted the car back. He was a friend of the warehouse manager, who he had known for at least a decade. They became very, very close during the COVID time where there were severe shortages and they had to work very closely together to keep the place going. While he was there, he walked over to the open warehouse door. It's a gigantic open warehouse door, as the pictures in the plaintiff's complaint suggest. He walks in and he's looking for the warehouse manager. A very senior, not the warehouse manager, but a very senior manager, warehouse employee, who we refer to as P in our affidavit, he sees Mr. Schmidt and greets him, and there were some pleasantries, and he said, "I'm here to say hi to the warehouse manager." P says, motioning toward the door, he's in the front office, okay? Motioning toward the door, like as if to say, go ahead and find him. The door was not locked, and Mr. Schmidt so testified. He did not use his key to open any doors. The door was open. And there's no direct evidence in the complaint or from any other affidavits of Market Basket. And I think, frankly, Your Honor, with respect to all of this, the fact that they have access to all these store managers, the warehouse managers, and they didn't get any affidavits and brought them to the court's attention, I think that the court can and should draw an adverse inference from that you can believe what Mr. Gordon and Mr. Schmidt said about what happened because they're testifying about what they saw. So the door was open, the senior warehouse employee is motioning toward the door, he walks in, he walks down a couple of hallways, he didn't see the manager, he walks to the front of the building, still didn't see the manager. So then he's on his way back, returning to the warehouse to leave. He runs into a woman who Mr. Schmidt knew because Mr. Schmidt always worked late, and this woman always worked late cleaning the place, and he always used to talk with her. He sees her, they engage in a discussion. Anecdotally, she says to him, "I'll say a prayer for you," which I only offer, Your Honor, as evidence that he remembers this clearly. And then the conversation ends and he walks out to the warehouse. The timing fits. In the complaint, they allege that he was in the front office area for about they said no more than 6 minutes. That's about 4 to 5 minutes doing what he was doing. He walks back out. By this time, the warehouse manager is there, along with P. He talks with them, pleasantries are exchanged. Nobody says at that point, or any other time, "You can't be here. I can't talk to you." They talked for a few moments and he left, and that's it. So to the extent that they try to demonize that, it's in order to, I think, to try to get the court's attention.
Well, let's do this. Let's assume that whatever you just said is absolutely true. He still has a key in his pocket. He can open any door. He can walk through there and open any door and look at anything he wants to look at. That's not injurious, or that's not injurious or detrimental to an existing business operation.
There was no injury alleged, Your Honor. No injury was alleged by that entrance. There's no allegation he took anything. There was no allegation that he did anything other than what I just said to you.
Okay.
And so just that alone is not contemplated as irreparable harm.
All right. Understood. You wanted to answer. You wanted to answer that?
Yes, Your Honor. Just three quick points in rebuttal. First of all, this argument that an injunction can count as irreparable harm to the defendant I didn't see any citation for that in their briefs, and I seriously doubt you could find one anywhere in Westlaw because it's, as the court points out, it would preclude the issuance of injunctions in virtually all cases. Secondly, Mr. Gellar's argument that the plaintiffs could bring in an expert to try and monetize the harm here, even if that were theoretically possible, he's making the argument to the wrong court at the wrong time. The time to have made that was 100 years ago to the court in the SJC in the Pease case where it was made, and that argument lost, and that argument has been rejected every single time it's been brought up since then in every reported trespass case that we were able to find involving repeated harm like this. And then the third thing is, the harm here, particularly for the headquarters store, is the message that the defendant is sending to every Market Basket employee, which is that, you may be reading in the papers that I was fired, but I can come and go as I please. Don't think you've seen the last of me. I walk right in, right past a sign that says employees only, right past a sign that is telling me I'm barred from entering this building. I'll go wherever I want in the building. I have a master key. He knows the company wants it back because it was in the same message that he was told he needed to bring the car back. Brought the car back, but he kept the key in his pocket. Message: I don't have to do anything they tell me to do. I'm going to keep defying them as much and as long as I want. And that, and this is somebody who these individuals have looked up to for 35 years as somebody who, it's like Mr. DeMoulis is practically his second in command. He's the operations manager. Of course they're not going to tell him you're not welcome here. Of course they're going to tell him, oh, whatever the board of directors says, take my word for it. You can be here. All of that is nonsense. That was an expression of consent to be in there. I think it's just a matter of common sense that when the chief operations officer of a company with 30,000 employees comes into a store and goes up to you while you're doing your job, and he's never spoken to you before, and all of a sudden he's asking you questions, he's saying, I see you, I know who you are, and when I'm back I won't forget which side you were on. That's the irreparable harm that we are alleging here, on top of the irreparable harm that simply comes from not having your property rights respected.
I understand. Do you have anything else you want to say?
Yeah, the only thing is, Your Honor, that I would say, and not in rebuttal to what Mr. Weinberg just said, but a question that I thought the court might ask, that I thought it might be helpful to answer, and that is, where do we go from here? Are we going to see you guys again? And the answer...
I'm not asking that question.
No, had you asked that question, Your Honor, I would have said that you're not going to see us again, because they aren't going to go to the stores any longer. They believe not that they violated any rules or that they did not have consent, and we do believe that the court should find that the plaintiffs did not prove that they have substantial likelihood of prevailing on the merits because of the consent defense and also because of irreparable harm and the balancing of harms. But the rules of the road have changed. We're here. They're defendants in a lawsuit, and they're not going to go back to the stores. So I respectfully ask the court to consider denying this injunction, because it's not going to do anything if they're not going to go back to the stores. But deny it without prejudice, so that the court keeps jurisdiction over this case, so to speak. The message has been sent by by Market Basket, the rules of the road have indeed changed now that you're a private citizen, and we do believe, in all due respect, that that's the jurisprudential thing to do here.
All right.
Yeah, can I just respond to that point?
You don't need to. You don't need to.
In the event the court wants case support, but
Yeah.
that is not, I have at least 5 cases here, including Supreme Court cases.
I understand that.
That's not good enough.
Okay. All right. Well, as you can tell, I really did look through all the materials. I thought it was both sides obviously are well represented, and you make good arguments. But I don't think there's any doubt with respect to the success on the merits of the claims in this civil trespassing case. My burden, or what I must find in this case, is a likelihood of success on the merits, and then that the plaintiff will suffer irreparable harm. Without the preliminary injunction, then the risk of irreparable harm outweighs the risk of irreparable harm to the defendant. With respect to the likelihood of success, there's 4 different notices that they should not be on this property, on the property of Demoulas in any way. To argue that somehow an employee gave them consent or a friend gave them consent to be on the property is irrelevant. Demoulas was in its rights to say in their May 28th letter, in their June 26th letter, in their August 6th letter, and their August 6th voicemail, that you should not be on the property. And it's not like it's not clear. That statement to them on each one of those cases, each one of those situations was clear and unequivocal, and they knew they weren't supposed to be there. To argue that the August 7th visit to Tewksbury was to see a friend or congratulate someone on a retirement or to return a car, to me sounds not that believable at this time. He left the car there, but he left the car with stickers or photos of Mr. Demoulas on the windows. That's a clear message. And then he went around the back when he couldn't get in the front. And having someone walk around the corporate headquarters who's been told 4 different times not to be there would create great concern for any business. And the harm, I don't necessarily agree that the harm is, the people in the future will be worried about them coming in. I think the harm is that these individuals were walking around a facility that they've been told 4 different times not to be in. They're not working there anymore. Great harm can come to a company from ex-employees doing what have you. Now, I don't believe for a second that these 2 individuals have the moral temerity or the inclination, what have you, to do any kind of harm to this business or any other business. They come from, they're hardworking individuals and obviously are dedicated. But on its face, it's not a good look. And so I do think the harms are real. I don't agree that the moving party has to show the irreparable harm in this case. I think that the Toro case controls here, and that the dictates of that case, it is a continuing trespass. 25 visits over the span of 4 days, I don't know how any court would not find that to be a continuing trespass. And there's more trespasses in addition to those, which one I think was maybe there could be some beforehand and could be some afterwards. I'm not sure what the number is, but it's 25 is sufficient for the court. But as I've said, irrespective of my position on the continuing trespass requirement, there is irreparable harm to mulas with respect to these trespasses or any future trespasses. I see no irreparable harm whatsoever to Mr. Gordon or Mr. Schmidt. There's no need for them to be on the properties anymore. And by your own statement, they don't intend to be on the properties anyway. And so the weighing the risk of the irreparable harm to the moving party and that of the defendant, I would come out obviously on behalf of Demoulas on that. So I'm going to allow the injunction. There's an order given by the plaintiff and as part of their motion that I don't think is proper in this case, but I do. I will say what I will allow or what I will give you. The proposed order, it says, upon consideration of the plaintiff's motion as well as the plaintiff's verified complaint, the exhibits thereto, and memorandum of law, the court hereby orders that the motion for a temporary restraining order is allowed. And then under that, it's the court hereby orders that 1, the defendant Joseph Schmidt and Tom Gordon and all those acting in concert with them are hereby restrained and enjoined from trespassing on any of the plaintiff's property, including stores, offices, and other facilities. Well, I'm going to enjoin Joseph Schmidt and Tom Gordon only, restrain them and enjoin them from trespassing on any of the plaintiff's properties, etc., but not and all those acting in concert with them. That is not appropriate. I don't think the language should be in there. The next one, they must return any market basket issued keys and all copies thereto. That I'm not requiring. I understand that that's moot at this point in any event.
Your Honor, I don't know that it's moot. We've received keys back, but they may have other keys.
Well, if it's not moot, I haven't heard sufficient evidence for me to say that they have keys in their possession still or not. That has not been a part of your argument. That's not part on a factual basis. I really didn't read enough so that I can make a judgment on whether they have keys and whether we should require them to return keys. So on that, I'm not going to order them to do that at this time. If you find further evidence or something that's relevant to that claim, I'm happy to address it, but I don't see it here. And then number 3, within 3 days of this order, Schmidt and Gordon shall certify in writing in full compliance with the pains. That's not required. My order's enough. I don't need for them to sign anything. My order's enough. They're enjoined from going on any Demoulas property in the future until this thing is resolved one way or the other, okay? Any questions with respect to the court's order?
Just one, Your Honor. So the court began by stating that, yes, you're granting a temporary restraining order. At this point, we're past that. We're on to preliminary injunction. So we just
Yeah, they're enjoined.
Yeah, preliminary injunction.
Yes.
Because the TRO would expire in 10 days.
I'm sorry. I was reading the, I was just reading the
Right, the original
proposed order.
but
Yeah.
that was from a couple days ago.
So it's just an injunction. Okay? Anything?
My only comment, Your Honor, is I'm always concerned about preserving objections. So to the extent that the court, in its remarks, found facts, the defendants respectfully object to those facts found in order to preserve their objection on the record.
All right, well, that sounds like a blanket objection, and I'm not sure what facts you're referring to. So I guess that objection will be reserved, and the appeals court will have to figure out what facts you're talking about. But I could clarify if I knew what facts you're questioning.
Well,
I don't think there's any disagreement about the 4 notices. Am I right?
only the timing of the
Okay,
notice.
and I don't think there's any disagreement that they went to roughly 25 properties during the course of these notices not to go there, right?
Correct, Your Honor. And I don't mean to quibble, Your Honor.
That's okay, but I want to go over these facts that you might say you're objecting to, because there's no disagreement on those.
Well, the one fact that I think you did find, and I tried to write it down as best I could, and if I didn't, and I don't mean to misquote the court, but that great harm can come. I think the court has to find that great harm has come. And so if the court is making...
I think I said that first, and if I didn't, what I meant was has occurred and or is occurring as they're, if they continued, would occur if they continue to do this. So has occurred, would occur if they continue to do it. So I think that's a good point that you raise. Anything else?
Nothing further from the point of view.
All right, thanks everybody.